So my name's Rob. I organize Idea to IPO. We've been doing events in Silicon Valley for many, many years. We hold events multiple times a week from San Jose to San Francisco. We always have a busy, busy calendar of events. I want to highlight 2 events that are coming up. This Thursday, June 27th, How to Become a Silicon Valley Success, featuring Andre Guziak, an angel investor. That's going to be in this room. Next Tuesday, July 2nd, Decision Making for Entrepreneurs. That's also going to be in this room. So check out the details for those events and all of our events on our website, ideatoipo.com. We launched on February 1st, 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 60,000 members among all our meetup groups in the Bay Area. We've completed over 2,100 events. By any standard, by any measure, we're the most active, most prolific startup event organization in Silicon Valley, bar none. All right. Thank you. Thank you so much. Our mission is to promote entrepreneurship, support entrepreneurs, build community, and provide value in the Silicon Valley startup ecosystem. To that end, we provide content that is practical, actionable, and relevant, stuff that you can actually use to succeed as entrepreneurs. And we believe in building community because Silicon Valley is an aspirational ecosystem. It attracts people from all over the world who come here to do great things. And I want to ask, who here is not originally from Silicon Valley or the Bay Area? Awesome. So who here was born and raised in Silicon Valley or the Bay Area? 2 natives. All right, let's hear it for the natives. Applause. So whether you were born and raised here or just got here last night, it's important for us to provide multiple channels for you to meet people, build relationships, and grow your network. So in addition to our content-oriented events throughout the week, we also have some fun events on Friday nights. In fact, this Friday, we have a movie night here in this facility, and we're going to be showing Avengers: Infinity War, and it's a free event. So check out that event this Friday if you don't have any plans. With regard to value, it is important that we provide value at each and every one of our events. So we make sure that our events are affordable, and if you cannot afford the cover charge for whatever reason, come talk to me and we can work something out. And at each and every one of our events, we make sure that we provide a delicious buffet meal. Is that a delicious buffet meal? All right. Well, thank you all 5 of you that acknowledged that delicious buffet meal. So let's hear it for Almond Law Firm for sponsoring that delicious buffet meal. Applause. Most importantly, though, at each and every one of our events, we want to make sure that we provide value for your time, which is your most valuable resource. And I have to ask, is anyone here getting any younger besides our speaker? So when you invest your valuable time to come to our events, we want to make sure that you maximize your ROI. We have many, many partners that help us do what we do: law firms, venture capital firms, angel investor groups, incubators, accelerators, colleges, universities, co-working spaces. Lots of players in the Silicon Valley startup ecosystem. Tonight, we're grateful to SVI Hub for hosting us at this beautiful venue. Is this a beautiful venue? Yes, it's a beautiful venue. So let's hear it for Bara and SVI Hub. Applause.
Hi, I'd like to thank you all for coming, and also thanks Rob for organizing this great event. I'd like to introduce you SVI Hub. It's a new co-working space here in Sunnyvale. We got a special offer. First month is for free, so you can come here for a month's work here, try wherever you like it. Also, we're going to start in September our programs for startups as well. So if you'd like to know more, feel free to ask me or grab a flyer. Everything's on the website. Thank you again.
A couple of our other partners are here tonight. I would also like to have them come up and say a few words. Let's hear it for Anita and Happiness Factors. Applause.
Thank you, Rob. I'm Anita, the founder and chief strategist at Happiness Factors. Happiness Factors is an emotional wellness and happiness company where we strive to be the #1 player globally providing so much happiness and empowering so much people that there are no deaths by suicide. Because people commit suicide when they're unhappy, when they're depressed, or when they don't feel good enough. So we have created a whole ecosystem right from the app, which is in the MVP stage right now and getting developed, to providing one-on-one coaching and workshops in companies like Google and Cisco, Apple, and other chambers of commerce and other places, as well as provide lots of trainings and lots of NLP, hypnotherapy, and MER, and past life regression analysis to help people be happy without using drugs, without using alcohol, and without marijuana. If you want to know more about it, then come find me after the event, and I will tell you how to find happiness without using any of the drugs or alcohol, which you might think will give you short-term happiness. But here we provide you techniques which gives you long-term sustaining happiness, no matter what life throws at you. Thank you.
All right. Takeaway, don't worry, be happy. Though our local mission is to support entrepreneurs here in Silicon Valley, our global mission is to democratize entrepreneurship and innovation all around the world. To that end, we maintain a robust YouTube channel, youtube.com/idea-to-IPO. Check it out. We have tons of videos there. We've documented and archived many of our events. And this rich, valuable content is available on demand, anytime, anywhere, totally free of charge. So whether you're in Sunnyvale, Palo Alto, San Francisco, New York, Maui, Moscow, or Timbuktu. Our partner in this endeavor is Tim Jeggers of Jeggers Films, perhaps the top professional videographer in Silicon Valley. Let's give it up for Tim.
Thank you, Rob. Thank you, everybody. So I'm Tim. I've been working with Rob for a couple years now. I manage the Idea to IPO YouTube page. Other than meetup groups and corporate events, I do all kinds of stuff, from promotional content for things like venues and real estate to product demonstrations, which some of you may be interested in. If you have questions about any of my services or where to find the info to get to the videos for Idea to IPO, feel free to reach out to me. I will be lingering around until the end of the event and a little bit after. And thanks for coming out and having us. And I'll pass it back to Rob.
All right, ladies and gentlemen, here's the schedule for the rest of the evening. Our featured speaker will present with an awesome slide deck. Audience members, hold your questions. We'll open it up to questions at 8 p.m. At 8 p.m., we'll take as many questions as possible. We would like you to use a mic, and this is going to help us produce a quality video, which everyone can use as a learning tool forever. We'll take questions till 8:30 p.m. At that point, we'll wrap up the formal program. If you would like a copy of the slides, you can email Bill directly. You can stick around, network, socialize, and connect. As a courtesy to SVI Hub, we would like to leave the building by 9 p.m. If at any time during the formal program you would like to get up and get some food, stretch your legs, use the restrooms, it's okay. We have a very informal atmosphere here. So I would like to introduce our featured speaker tonight. He is one of the top intellectual property attorneys in Silicon Valley. He's the founder of the Ahmann Law Firm. Most importantly, though, he is passionate about helping entrepreneurs succeed. Let's give it up for Bill Ahmann. Applause.
Thanks, Rob. So when we were preparing this, Rob and I were preparing this presentation, I told him that I was Almond Law. I'm now Almond Cloak. So we're growing. We're now to half a dozen people. So getting bigger and bigger. It's still strange to introduce myself as a small law firm because I've been in big law for 20 years. Usually I come up and say, I work in a firm with 900 attorneys. If you have any questions about anything, I can find the person. Now, basically, it's just so if you have any questions about IT, that's my specialty. And that's the focus of my firm. You can tell from the title here that we're talking about how to cut your patent-related expenses by 90%. That doesn't mean you walk into the office and say, I know that patents cost $10,000, I'd like one for $1,000. That's not really the way it works. But I have seen throughout my career an incredible amount of waste, unnecessary expense that goes into patent-related prosecution, and especially litigation. And so I attempt to advise people about how to avoid spending money that's going to become wasted and avoid the occasional, well, I don't want to sound negative, so let me tell you a little about my dad. So my dad is a surgeon. I got, when I was younger, I tore a ligament in my ankle. I went to my dad and said, "Dad, what do we do?" And he was like, "Surgery." So we did surgery, and then a little, or I guess a year or two later, when my ankle was bugging me, I did a little research and I found out the prognosis for a torn ligament, if you don't get surgery, is the same as if you get surgery. And I said, "Dad, why?" Well, I think I'm a surgical surgeon. And I think you get that type of thing with law firms as well. So you'll come in and you'll say, "Well, I have this problem. What do we do?" Litigate. And you don't have to litigate all the time. Usually it's the wrong answer. It's not that they're evil or attempting to sell you a bill of goods necessarily. It's just that that's what they do. So when they see a problem, litigate. And that's something I can help you steer with. So the topics for today, a big one, I get this a lot, protecting IP before you have an IP budget. So you start protecting your IP as soon as you start your company. Right? And the things that you do once you have a company depend entirely on your budget. So if you have, or I won't say like $0, but if you have $100, there's things that you can do. If you have 1,000, there's things that you can do. If you have 10,000 that you can spend, then there's things that you can do. And they're all different, and they're all correct, depending on what your budget is. How to get the most from your IP budget, that's a big part of what I do. How to use patents. Typically for a startup company, that's you use your patents for evaluation purposes. You're not going to go out and enforce them, typically. That's almost always a bad idea. But we'll talk a little bit about that. And defending against patent infringement lawsuits. And the key takeaway with this fourth topic here, the patent litigation defense is budget-based as well. If you don't have any revenue and somebody's suing you, then you should set the budget for your patent litigation to be a very, very small amount of money. Right? Don't get confused by the fact that litigation typically costs patent litigation is between $1 and $4 million typically. So that's true. But if you're not making any money, then the person who's suing you is going to get a percentage of that, which isn't much. So you don't need to blow your budget on legal fees. And I can help with that. The first part of protecting your IP is trade secrets. It's inexpensive to get a trade secret. That's one of the things that you can do for $0. And the key thing with trade secrets is put everything into a secret box. And to provide an image that will maybe help you remember what I mean, Mr. Ping. Does anybody see Kung Fu Panda? So he has a noodle shop, and he sells a noodle called secret ingredient soup. And the secret ingredient of that, I think everybody knows, is nothing. That's a trade secret, right? So what do you put in your secret box? Literally everything and nothing, right? It's all a trade secret until it's time for you to take it out. And just be disciplined with your trade secrets. They don't expire as long as you implement realistic procedures. Realistic's important. And then you follow the procedures, right? You can make everything a trade secret, including something that really isn't a trade secret once you find out it's nothing. The reason you implement realistic procedures is you are better off having no procedures than having procedures that you don't follow, right? So the trade secrets is kind of common sense, but just make sure that whatever you decide in your common sense way to follow is something that you actually do, right? The most common being need to know, right? Share information on a need to know basis. If you decide somebody doesn't need to know something, don't share it, right? Pretty straightforward. Confidential, stamp everything confidential unless it's not, right? So confidential, stamping something confidential, and then in disclosure somebody discovers that there's all these documents out in the wild that are stamped confidential that you've shared with everybody, it weakens the mark confidential. So it's great to mark it confidential, just Mark it confidential only if you're going to treat it that way, right? So that type of stuff. It's not rocket science, but it is important to be to follow your rules. I think we're going to push questions off to the end, but if it's quick.
May I take
Can you get the
slides?
We will share the slides, yeah.
Okay.
We'll share the whole slide. Yeah. All right, so the categorization of trade secrets. I don't think you necessarily need a list of this, just to give you some ideas about trade secrets that I find to be valuable. I deal a lot in patents. So one of the things I love is patent disclosure forms. Right? So you can get, I give all of my clients a patent disclosure form if they want it. It basically describes, what the metes and bounds of your invention are, prior art if you're aware of it, things like that. I love those things. So you just file them. We'll get to what you do with them later. If you don't have the budget, you don't file patents, but you can still submit a patent disclosure form to your, to whoever's handling your materials. Product information, of course. Nowadays it's pretty easy to maintain all of your information because it's, storage is cheap. But keep all of the information about your products as you develop them. What people used to call lab notebooks, those are still kind of cool. Negotiation strategies are useful for patent attorneys too, right? If you're discussing something with a potential partner, I like to know what you're discussing because your patents should always be focused on what you're doing, what's valuable to your business, and negotiation strategies sometimes play a part in that. And competitor information, which is extremely important once you have the budget to take advantage of it, because you're going to be filing your first patent on what you do, but you're probably going to be filing your 20th patent on what somebody else is doing, right? So you're predicting what the market's going to be. You don't always target a specific company, but you do kind of think, what's the world going to look like in 10 years? And even if you're not going to do it, you might want to capture that. So competitor information is quite useful. So what do we do with all this trade secret? You take a technology audit. That's a term of art I think other people in the Valley occasionally will use. It basically just means you talk about what you're going to do about your trade secret stuff. Right? The results of a tech audit are one of three things. Always. I don't think there's an exception. The first decision is you're going to keep it a trade secret. That's easy. You just put it back in your secret box and you don't tell anybody about it. Right. The second is what I call a defensive publication. It's typically not a desirable approach for a relatively small or mid-sized company. It is an approach that's taken relatively frequently with very large companies. You'd be amazed at what IBM will get in their patent portfolio. I saw one patent for lining up in a queue to go to a restroom on an airplane for IBM. I think that was IBM. So, they do all kinds of crazy stuff. But even IBM at some point will have, I don't think we want to do that. So they publish it. They just have a periodical that comes out and they publish all of their ideas. And because they have now published it, they prevent other people from getting a patent on that, right? The ability to prevent somebody from getting a patent by defensive publication is dubious at best. That's why you rarely do it. But if it's pretty worthless, you don't really care, then you can publish it. A more common defensive publication is when you say, yes, this is important for our business, but we don't have the budget to patent it. And you can't run a business entirely on trade secret. You have to, at some point, tell somebody what you're doing, right? So you may have to explain what you're doing to get somebody to buy your product or to get business. When that happens, I like you to refer to it as a defensive publication. The difference between a publication and a defensive publication is a publication is just you put it out there, right, whatever it is, and you don't really care. A defensive publication describes in detail what you're doing, so that you can make sure that it's not just to get the market. It's also going to prevent people from attempting to claim precisely what you're doing. So the better your description, the better the chances are that somebody else won't be able to get a patent on it. So it's just playing the odds. And the third possibility is patent. And as I alluded to, patent is something that takes a budget. The number I give to people typically for patent, you don't really have a patent play unless you have $10,000 as an annual budget.
So how do we implement the trade secret in our daily operations in a company?
You don't say anything to anybody outside the company.
Is it a virtual concept? Like, say, for example, there is something, so do we say there is a practice of marking confidential?
Yes.
So how do we implement? Because almost everything could be a trade secret. Like how to communicate or how to regard something as a trade secret in operations.
It depends on how complicated you want to get with trade secrets, right? Larger companies will always have things that are, for example, document retention policies, and they won't talk to anybody under NDA, or will need an NDA in order to do something. And it's all going to depend on the company, right? And what you want to accomplish and how much effort you want to put into it. If you decide that as a startup company, you really don't have to share very much except to investors, and when you start marketing, what do you put on your website, that type of thing. All I'm suggesting, I'm not going to prescribe a trade secret regime for you. We could talk about it, and it would be different for you than it would be for somebody else probably. But what I'm suggesting is just do it intelligently, right? So if you decide that you're going to describe something on your website, that's a defensive publication. Think of it that way. You're sharing it for a reason. Why are you sharing it, right? If people don't know about you, you need to let them know about you. So company name, a little bit about what you're doing, that type of stuff for your web page. For trade secret, if somebody doesn't need to know about it, that's what you protect. That's what you keep secret. It's like secret ingredient soup. It might be nothing, but protect it, right? Just don't talk about it.
I have a quick question. The Tesla CEO had published all their car making patents publicly. Was it defensive, or was it just because he said that he wants other companies to manufacture electric cars?
Yeah.
So,
Anything in my view, Tesla didn't do that. It was PR, and I love when companies do PR. That's a good thing. When they're trying to be good for the world, that's awesome. Yeah. So I'm not going to try to diminish that. But in my mind, it's defensive publication, right? As the attorney, I would be saying, all right, are you sure? Right? You don't want to try to protect this yourself? Okay, great. If you want to do good deeds for the world, wonderful, right? Publish it. And it was effective, right? So nobody can get a patent on what they disclose. Now, I think they actually disclosed patents to begin with.
Yeah.
So you can't get a patent on something that's patented by definition, but it's still an
but you can
interesting
still
point.
use that process.
But the CEO also said that anybody can use it, so that works against it.
Well, it depends, right? So we're getting a little sidetracked, but patents are the right to exclude, and you have to really keep that in mind. It's not a license to do something. It's a ability to stop somebody from doing exactly what's in that patent, right? And if I get a patent on, just use something simple in front of me. How about this bell? If I get a patent on the top of this bell, and I get a patent on the bell, the ringer, and I get a patent on the base, and I say, well, I'm going to disclose to everybody this part, but I'm not going to disclose to everybody. I'm going to keep this for myself, and I'm going to keep the base for myself. Well, good luck doing this without the rest of it, right? So you have to be careful not to treat it like it's a license to do something, because it's really not. And the reality of patents is that it's a dance that gets very expensive regardless of who's right? So you want to do the right thing just to make sure that you position yourself the correct way, but don't put too much weight on any individual one patent. Think of it more as a strategy than one piece of paper. So factors to consider in a tech audit. So there's another thing that I think the takeaway is going to sound surprisingly simple, but it's very important for you to remember, right? Budget, obviously. Don't spend more than you can afford, right? If you can't afford much, that means you don't have revenue. So make sure that your budget is realistic. Now, as a startup company, you always have trouble with resources. So you are going to take some chances, right? It happens. And you might spend more than you really want to spend. But at some point, it's going to reach a equilibrium. And you're going to say, well, our revenue, it's going to depend on the space you're in. But just to pick a simple number, say if you have $10 million in revenue, you could have a $100,000 patent budget, something like that. Right? It just goes to your patent budget. I just made that number up. It's sort of realistic, but other factors to consider: the return on your investment. So why are you getting the patent? Right? Make sure that it's appropriate for your business. Don't just file something like I still think it's funny when I see patents, like the queue in the airplane, and I saw one once where it was like a diver's helmet, and the image was a cactus sitting on a guy's shoulder, and it was a patent where you could have this helmet, and the plant inside would create oxygen for them to breathe. Just stuff like that, and I'm thinking, why? Like, get something that's actually going to be worth something, not worth less. Now, worthless is sometimes valuable. I think there's another kind of funny thing. I find it difficult to file worthless patents, but a large part of my practice is invalidating patents. So I create them and I destroy them, not the same one, it's always different ones. And the one of the patents that I had a great deal of trouble with was, so Foxconn sued my client Lotus, and Foxconn is a small company somewhere in Asia, and they sued using this huge portfolio. I mean, they had a huge portfolio. And they used 10 patents, and I killed off, like, I don't know, 6 of them, and some of them were no longer infringed, and there was this one patent that I couldn't kill, and the reason I couldn't kill it or even get an amendment was because it violated the laws of physics. So no prior art. I couldn't find any prior art that violated the laws of physics. And that's a little bit of a funny thing, that sometimes an attorney might refer to this as intentional obfuscation, patents like that. I hate them, but just keep in mind, every once in a while, there's value to doing something that doesn't make a lot of sense, right? So it's kind of funny when you think about it. And then the last thing to consider is bar dates. These, in my view, are the least important. They're usually the thing that cause the most freakouts. Oh my God, we have to file. A bar date is, in the United States, if you publish your technology, you have 1 year from the publication date to file for patent, right? So 1 year from that date is what I refer to as a bar date. In other areas of the world, you have until the end of the day to file for patent if you publish something. It's called absolute novelty. So the bar date is the day that you disclose. Right? So the bar dates also come up in situations like you file a provisional patent application, which we'll talk about a little bit. 1 year from the provisional filing, you have to file a patent, a non-provisional application. So these bar dates are something you should consider for tech audits, but the practical reality of startup life is they don't matter nearly as much as they're made out to be, right? And you're typically going to have iterations on your tech. And if you're doing it properly, you've already considered, hey, I don't use this laser pointer enough. Is this, yeah. You've already considered budget. So if you're already considering the budget, your bar dates become less important, right? If you don't have the budget to convert that provisional to a non-provisional, you're not going to do it, and you'll deal with it later. But you're going to have a version 2.3. And when you come out with your version 2.3, you say, yeah, we couldn't get a patent on version 1.4. That sucked. But 2.3, obviously we've been working on it. There's a reason why we think it's going to be better in the marketplace. And that incremental improvement, sometimes counterintuitively, is more valuable than the pioneering patent that took so much effort to put in place in the first place. Because if you don't do that simple incremental improvement, you're not competitive in the marketplace. Right? The point of patents, return on investment. Not creative, not sweat of the brow. How valuable is it in the marketplace? And so I rank these in order of what I think is important. Budget first, return on investment, and the bar date, something you should think about, but don't stress over them because there's usually a way to deal with them. Okay. So traditional patent prosecution. This is what I try to encourage people to avoid. The old way of doing patent prosecution is you're the person who comes up with the invention. You say, hey, patent attorney, I got this idea, this is what it is. And the patent attorney says, cool, let's file a patent and cover that. And normally that's kind of the way it goes, right? If you picked the wrong thing, if you didn't realize that budget was most important, if you didn't realize that I don't care about what your tech is, I care about what your business is, then I get a patent on your tech, which is worth 3 cents in some component that's manufactured in Taiwan, whereas your business is worth millions, right? So it results in haphazard patent portfolio building. You don't put the value in the place where it belongs because you haven't sorted through with your attorney and with your CEO and your engineer. A lot of times that's the same person in a startup, but you need to get you need everybody to agree where's the value here and do that. You don't normally have to file multiple patent applications as a startup. And my recommendation is always one. I get people who come in and say, well, we got 5 patents we need to file. And I say, you sure? Because I could do one. And in most cases, 1 is the right answer. Right? If you're going to do 5, you have parallel filings. 5 parallel filings equals 10,000 times 5 per year. And then when you hit the foreign filing dates, multiply that by the number of countries into which you decide to go. It quickly spirals out of control if you're not ready. And you also will get low quality, because if you're identifying the invention, maybe you're the CEO, and that's good because you're probably focused on the business. But if you're the CEO saying, go tell him your invention, engineer, I might not get what's valuable. And so you get business goals secondary when you're dealing with an engineer who doesn't understand the big business goals. You also get what I refer to as high precision with poor accuracy. Right? You're very precise about the tech, but the target is not what you should be shooting for. Right? So this is a common problem. And foreign filings, especially with an approach like this, suboptimal. My experience, even though I say this is going to be a problem for every client that comes in my door, we're still close to 80% of foreign filings go abandoned, primarily for budgetary reasons. Yeah, as my grandma used to say, people's eyes are bigger than their stomach. So keep in mind that the budget is times the number of countries you're going into. And most of the time when you say, all right, it's time to go into all these countries, where do you want to go? We want to go into Europe and China and Japan. Okay, yeah, that'll be $50,000 a year in addition to what you're already paying. The interest goes away, right? A lot of times this, this is a lot of times, they actually will go forward with the initial filing and then abandon it later. You know, when you have a budget crunch, it's like, what are we going to do? Well, we got to get rid of some of these patents, right? And the foreign ones go first, quite frequently. So I approach patents a little bit differently than what I call patent prosecution shops. Patent prosecution shops actually prefer that model that I'm telling you is no good, because there's less upfront work. If you come in and say, I need to get an invention on a patent on this, like, cool, I see what that is. I can write a patent on that. Very simple, right? Just write what you tell me about. It gives you less upfront work. You can be more competitive. Patent drafting is a pretty competitive business, right? So people are always trying to cut the prices down just a little bit. And that's just much easier if you come in and tell me what to file and I don't have to think, right? So less thinking is easier. Less business advice. So if lawyers traditionally have avoided giving business advice because you can get into trouble. You're not really supposed to give business advice. Silicon Valley attorneys give business advice all the time. So it's kind of a newer thing. But for the most part, if you come in and make it unnecessary for me to give you business advice, it's easier for me. And you'll normally will be less disciplined in your approach if you're just saying, let's file patents on these. There's no desire on my part, I'm being cynical, there's no particular desire on my part to say, well, what about this part of it? Isn't that important for your business too? We better put that in there too, because I can just do that later, right? So I can file another patent on that thing you forgot to put in there. And there's more false starts. So you will prepare your patent, you file it, it's not in, the thing you need is not in there, so you file another thing, and then you get a whole bunch of different patents pending at the same time. A lot of times you have to consolidate them, which causes some damage. You abandon applications because they're not valuable enough, things like that. It happens quite frequently. And the thing about all of these things that are bad for you is that they're good for me, right? More patent filings, less work, less risk, everything's easier. That's why you still see the traditional model. And law firms don't even like the old model, right? So for the most part, you'll be hard-pressed to find a large number of large law firms that love patent prosecution. They're pretty rare. And they don't like it because patents are seen as commodity work. Patent prosecution is high risk. You have to pay more in insurance for patent prosecution, because if you miss a date, on Viagra, you can be on the hook for quite a bit of money. Patent prosecution is difficult to leverage. So in an immigration practice, for example, you can have a whole bunch of associates who are all filling out forms and stamping them and stuff like that. With patent prosecution, it's very difficult. You need engineers, essentially. So you need tech people. Harder to find, difficult to find good people. So you just have a much harder time building up a practice. Bad prosecution is good for law firms. Okay? You screw up patent prosecution, oh, patent prosecution was messed up. We need to fix this in litigation. Right? So the verticals actually benefit from poor patent prosecution, so they don't really want to do it anyway. Firms also have an issue with maximizing short-term revenue. The focus is always on billable hours. I don't like billable hours. I think they're a conflict of interest with your clients, but it's the model that firms use. And because they want to use billable hours, and because patent prosecution is inherently a commodity work, right? There's a certain number of hours it should take to write a patent application, and people know what that is. If you ask somebody what's a certain number of hours that it should take to do a patent litigation, your guess is as good as mine, right? The number is large. So there's no windfall with patent prosecution. And also the traditional model, as opposed to the business model, gives an immediate realization on hours. So if somebody comes in and says, I want you to do this work, you can, with some confidence, depending on who you are, write that patent application in 25 hours, 40 hours. If you're brand new at it, it'll take you maybe 200. But for the most part, you know your number of hours. So you can bill it out relatively easily. And the factors that make patent prosecution undesirable for law firms, you can fix with better with a better strategy, which typically there will be some resistance to because it takes more work. So, responsible patent prosecution. How do you do your patents? The tech audit. So what I described to you is actually the best way for you to start the process of protecting your patents. The tech audit, as I mentioned, always starts with how much budget do we have. That's going to determine how many buckets, I call them buckets. How many buckets do we have? So, good number to remember, $10,000 a year. That's patent prosecution. What's your budget? Well, if it's $10,000 a year, you got one budget. You got one bucket, right? So when you do your tech audit, you say we have all of these different inventions. You decide, are there any bar dates? You're going to file something. So anything with a bar date, you put in the patent. Right? Anything that's valuable to your business that's not going to be, you're not stealth about or anything, you put in your patent. Everything goes in the patent. Right? You can get a patent on, you can put in your patent anything you want. Right? You can put a rubber ducky, an automobile, a space shuttle, cell phone, all in one patent application. Doesn't matter. There's no particular problem with that. Eventually, over time, you might have issues with licensing because it's difficult to separate out those different inventions. But as a startup, you want to punt, right? You got other things you need to worry about. Put all your inventions into one patent application and worry about separating them out when you have the money to have multiple patent applications pending at the same time, right? So instead of parallel filings, which is the traditional model, you go with serial filings. You file your patent application, you include everything that's important to your business, hopefully the pivots that you might go to, things like that. It's going to be high quality because it's aligned with your business goals, right? When you read this patent application, or when an investor, which is typically your target, reads this patent application, they should say, oh, that's what I'm investing in, right? If you give your pitch to an investor, and when you're done with it and they say, well, what's your patent on? You just say, that. What I just told you, that's what our patent's on, right? That's your goal. It doesn't matter if there's lots of different tech in there. It matters that that's what you're selling as your company. It's extremely high accuracy because even if you pivot, usually you don't pivot so far that the patent won't apply, right? A lot of times pivots make it seem like there's a really big change, but frequently the pivot is actually within the bounds of the tech that you were working with anyway, right? You can use your tech in a mobile phone, or maybe you can use it in an automated vehicle. It's the tech is just being moved, right? So you're able to do this with serial filings. You're able to focus on the current set of claims that's important to your company at the time. You're able to pivot, maybe change your claims, right, after your patent is allowed. Right? So when your patent is allowed, what I mean by serial filings, when your patent is allowed, you can file another patent application that includes the very same disclosure, the very same drawings, but a new set of claims. Right? You have now established that your patent budget is $10,000 a year, and you have 10 different inventions that you could have got in parallel that instead you get over the course of 20 years, in the order that's most important to you. There's often questions about this thing, so if you want to get back with me after this is over, I'll explain it again. Responsible patent prosecution, I think a lot of this stuff is in some ways common sense, and in some ways, to the extent it's not, you can fluff it, you can fluff over it a little bit, and it shouldn't cause you too much stress. Because with a patent budget of $10,000 a year, it just doesn't matter what all this stuff is. But if you have a little bit of a larger budget, then you might start considering, what is the ideal budget for this market, right? In certain markets, you need to worry about, some markets have granular tech. Pharma is a technology space that is fundamentally different than high tech. Even the laws are different. The interpretations of the laws are different. And when you do get a patent protection on a molecule, you're getting protection on a very specific thing. I usually talk about Viagra. I think it's a fascinating patent play. But the thing about Viagra is, when you describe Viagra, there is exactly one way to make it, right? Windows operating system has thousands of associated patents with it. So the approach that Microsoft has to patent is basically, it sucks we got patents, but what are you going to do? The approach that a pharmaceutical company will have with patents is, yay, they're awesome, because I can stop anybody from making the molecule that I want to make. And it works very much like that when you watch how the various lobbies will approach the Congress to change the laws. Pharma has always been a champion of patent, and high tech has always tried to tear it down, right, at least as long as I've been practicing. It's an interesting thing that happens in foreign jurisdictions as well. Like the reason why India's patent law was so bad for so long, even though there's a relatively large tech population in India, has been pharma, right? There was no champion of patent law because in India generics rule, right? They're not brand, so they don't want strong patent laws in India, and that has harmed tech. Recently, it looks like it's been turning around a little bit, but for the most part, patent law in India is very weak, and part of that is because of the pharmaceutical lobby, right? And national self-interest. And China, on the other hand, had a very interesting approach for protecting patent in that they had this. They decided to give all of the Chinese tech companies basically patents. It was through what they called design patents or industrial design patents. We don't do those in the United States because they suck for the most part. But some companies can make use of them, like Apple and some automobile manufacturers. But design patents, for the most part, you can think of them like a copyright. It's like you walk in with your design patent and you say, "This is what we did." And everybody's doing that now, and you show the image of your Apple phone, and you're like, everybody's phone looks like that. Well, if you're a start company and you walk in, and you say, everybody's doing this, and they're like, what's your name again? Right, your design patents aren't worth very much. So we don't do them. But China essentially gave them all away to all of the tech companies in China, and then enforced them in the courts. Right, and so they had a national interest in protecting their patent law, and that's how. Even though pharma isn't as big a play in China or as important, front and center as you find in India or the United States, because they have this national interest in protecting patent law, Chinese patent is extremely powerful, right? So if you want protection for patents anywhere in the world, I would say the best place, the cheapest place to enforce, the most effective strategies, the fastest speed, it's China. I hate when my clients get sued in China. Right, that's a scary place, but it's very strong patents in China. Some markets, again, I think you can punt on this because it's not going to matter until you start having a larger budget. But in the IEEE 802.11 space, there's a lot of litigation, right? So typically, in a place where you have more litigation, you'll have more patent. If you're in a space where there's relatively little litigation, your budget for patent relative to your revenue is lower. And then standards. Standards essential patents are relatively weak, but once you get large enough and you start getting on standard-setting bodies, make sure you at least bring it up. You want part of your portfolio, not all of it, but you want part of your portfolio to be standards essential because they're easier in some ways, but the royalty rate that you get through these things is pretty small. So. Oh. Yeah, my secretary laughed at me because I spent a long time on that Dart graphic, and then I didn't even sell it. So, you like my Dart graphic? So the idea is, instead of the traditional model where you're just throwing darts at the board, with the intelligent patent portfolio building, you have your dartboard, you're always throwing an exact bullseye because you have what you need all there. Uses of patents. I think probably you would figure these out if you sat down and thought about them for a little while. But at the bottom, at least for a startup, the least important is what most people think of immediately. It gives you the ability to sue somebody. That's a bad idea almost always. It's very expensive to enforce your patents. So I think of patents as something you're going to use for somebody else is going to sue somebody on, not you. Right, if you're a startup company, right? It's just too expensive. And until you have a large enough company where you can have smart people in both the division that's associated with enforcement and the division that's associated with building your business, it's too early to enforce, right? Because you don't want people to get sucked into the wrong place when they should be focusing on typically building the business, right? So normally it's valuation, right? When you first file for patent protection, this is something that you can give to your potential investors to say, we have value here. A lot of people don't like to talk about finance in bankruptcy, but patents are also useful in bankruptcy. You know, if your company goes out of business, I've seen patents specifically are often like 80% of the value of the company at the end of the day. So I think it's important for valuation at the end of life as well as when you're merging or being acquired, that kind of thing. Inhibiting competitors is slightly overrated, but it does happen. If you get a patent in something, that's great. It's not going to stop. If I'm a company, I'm not going to stop doing what I do just because you've got a patent. I'll get my own, right? So I think savvy competitors are not going to be swayed by the fact that, oh no, you got a patent, we got to close up shop. It just doesn't work like that. But what it can do is get in the way of investment. So I have seen this happen. If you have patents and you're seeking investment, and there's other similar companies all seeking investment, and you don't sue them because investors don't like companies that are in the middle of a lawsuit. That's terrible, right? So don't ever do that. But if you do say, yeah, they're doing something similar to us, but we have the patent, that actually I hear occasionally can sway things. Leverage. This is actually something I've seen quite a bit of. I do software licensing and tech licensing, things like that. And the very nice thing about having a patent is not doing the patent license. It's keeping your friends honest, right? Keep honest people honest. As my brother-in-law owns real estate, and so he likes to put locks on his property, and it's rural property. So anybody who goes out there can, it's locked, bang, break in. So he says, well, I'm not trying to keep the thieves out. I'm trying to keep the honest people out. So it's like that. You do a tech license or software license with someone who's your friend, and you say, yeah, let's keep doing this license. And they're thinking, well, we could do this in-house. And you just mention, yeah, but then you need a patent license because I also patented it. Right? So keep them honest, keep them focused on the tech license, and don't let them stray. That works reasonably effectively. Cross-licensing, another way to settle disputes rather than see the litigation to the end, which is actually pretty rare. Most of the time, you're going to try to settle. And you have a couple of options. One, money. Two, cross-license. Right? So if you're going to pay them money, great. If you have some extra patents, you can sometimes just cross-license, live and let live. And it can get you away from paying more money in a deal. Design freedom. This is, it's a common entry in, valuation type discussions or uses type discussions. It's really not much different than being a startup, right? So you get a patent to sort of carve out your niche. And if you're going to go into a new space, same thing, carve out your niche there, then move in. Right? Patent marking. I think this one's funny, because I could file a patent application for you for probably $130, and you could say patent pending, right? I could file the phone book for you, and you can say patent pending. So I think it's kind of humorous that some people put a lot of value in patent pending. It's actually kind of ridiculous. But I've heard that there are those who like to say we're patent pending, you know. And I think it, in combination with we're patent pending and it's all, and this is what it is, and you show it is actually a good document, can have some weight. But this is something that comes up with relative frequency. Can't say patent pending if you don't have a patent pending. It can cost you money if you do. And creating business relationships. Just the fact that you own something. I think of this in some regard as showing that you put your blood and sweat into it, because everybody knows it's not trivial to get patent protection. It takes a relatively significant budget. So you show you're serious if you have patents, and that can improve business relations. I don't think I'm going to go too much. This is actually, from this slide on, is my favorite topic. I think it's so fun. But you won't think it's nearly as interesting as me. Your eyes are going to start glazing over. And so I'm going to stop as soon as everybody's asleep. But the awesome thing about patent litigation defense is in the historical, the way that the history has unfolded with patent litigation. I just find it fascinating. So I've been in big law for 20 years. And basically, when I got in big law, that's when patent law went nuts, right? It's been in chaos ever since I started practicing. And the people that I worked with and my mentors at the time when I just got out of law school in like 2000, we're talking about a time when patent law was relatively stable. And like, what? Because the Supreme Court gets a new thing and they change the law and you're like, my patent's invalid, And so, but at one time it was relatively stable. It was like other areas of law. They weren't changing it all the time. Now it changes constantly. But the approaches that you've seen over the years, since 1981 at least, was you could invalidate patents at the patent office. When you invalidate patents at the patent office, you're basically dealing with an engineer, right? Patent examiners are engineers, right? They have technical backgrounds. And so when you talk to them, you're talking about tech. You don't talk, you have to talk about law sometimes, like the Supreme Court decisions that, occasionally. I've had conversations with examiners saying, yeah, you're right, but we have this rule from the Supreme Court. I can't do that. I don't know what to do. Maybe you can appeal. But 1981, the reexamination procedure was introduced, and it's been amazingly consistent. Uh-oh. Can you read that? Anyway, I think it got blurred out. But this is 1981, and you find that over the course of those first, until 1999, when a new procedure was implemented, you had, I know it's hard to see, but you had about an 11% invalidation rate with examination. So if somebody sued my client and I wanted to invalidate the patent rather than go to litigation, I could kill it about 1 in 10, right? The procedure cost 20, 30 grand. It was relatively inexpensive. Litigation in today's money, 1 to 4 million. So it was a pretty good deal, even though the odds were relatively low. Now, I got into practice around this time, 1999. That's when I first started practicing law. And I remember inter partes reexams were just introduced, and they were introduced in response to lobbying. Right? It was a huge deal. The decisions that were coming down, this was software was a big deal, and you had all these people saying software is not patentable. It is, but back then it was a huge deal, and the Congress, responding to all of the arguments from the various lobbying groups, needed a way to kill patents, right? Especially software patents, because everybody hated those. So they came up with this, basically, I would call it an executioner for patents. Right? And it was the inter partes reexamination proceeding. And it wasn't done in a way that I would suggest was good for the people who wanted to invalidate it. Ironically, it was good for law firms. Right? So what they managed to do was introduce a new policy, and sorry it's hard to read, but basically you had about a 42% chance of invalidating patents. Quite a bit better. But it was a fair bit more expensive, and it also resulted in what's called estoppel. If you decided to do the inter partes reexamination, you got one shot. If you failed, Ex parte reexamination was no longer possible, and you had to go to litigation. Right? That was the way to resolve it. And law firms were fine with that. They're like, okay, so 42% of the time the case is done, and the rest of the time you have no other options. You have to go to patent. You have to do patent litigation. So it wasn't too bad. That was the heyday of patent litigation. And the kill rate remained relatively consistent. It was 42%. It went a little bit down, but it was still pretty good. Over a third of patents in any given year were invalidated with that process. But over time, people started getting really angry about this. And they were saying, I was there listening to it, patents are out of control. You got all these patent trolls. We need a better way to kill patents. This 42%, that's not good enough. We need something far better. So they came up with an inter-party review. And unfortunately, the acronym's the same, IPR. But at this point in time, IPR was a brand new thing. The interesting thing about that, when they first started doing inter-parties review, the kill rate for patents was fantastic. They were killing them off at about 80%. Nowadays, it's down to about 42%. So after this process, and after the fur died down, it's exactly the same as inter-parties reexamination, with one big difference: 10 times as expensive. So, if you follow this bottom path, ex parte reexam was about 11% kill rate every single year. It really hasn't varied much at all. It's been super consistent. And over this time, when the inter partes reexamination was first introduced, you started to get a stay. That's a stay in litigation is when you tell the judge, stop doing what you're doing, we're going to solve this somewhere else. And the judge says, okay, no more litigation cost until you're done with the ex parte or inter partes reexamination. So the stay rate went up to about 70% at this point. And now let's go back up to this right here, the cost of these various things. I've done a lot of these ex parte reexams, and typically I file two. One will make them change the claims. The second one often kills it. Sometimes there's three. But I think of it as an ongoing strategy. If you don't have a serial patent prosecution practice, filing continuations, and you have one patent in your portfolio, I'll bet you I can kill it. So how much is your patent worth? Well, it better be worth more than $100,000. Because if your competitor thinks that your one patent is worth $100,000, more than $100,000, they can pay me $100,000 and I can kill it with pretty high probability. Serial patent prosecution practice, safer because you have a moving target, right? Your patent issues, you file another one. They kill that one, you get claims directed to something around that space. Or you file 10 new continuations off of it. So you can keep your costs higher. Killing patents costs about $100,000. Getting patents costs $30 to $50. So it's a little bit cheaper to get them than to kill them. But what I've found is, at least my statistics, with the 3 re-exams, usually they're dead after 2, or not usually, but frequently we're done after 2. I just use industry statistics rather than my own, and the kill rate is better with this $100,000 strategy than it is with any other strategy. Every other strategy is far more expensive, right? Inter partes review is $300,000. This $100,000 is 3 re-exam practice or 3 re-exam attempt. It might be 130, so I'm going order of magnitude, but much cheaper, much better kill rate, right? The lawsuit approach, far more expensive. You don't really kill patents with any frequency at all in litigation, right? If you go to litigation, your win rate drops to 33%. That is, if somebody sues you and you get in front of the court, you're going to lose 2/3 of the time. Right? So it's bad odds. You actually have, you win 2/3 of the time from the time the lawsuit's filed, but that's because of the re-examinations, inter partes review, things like that. So you kill them off through these other procedures. But if you make it to trial, the patent owner has a huge advantage. So the kill rate, much higher for the much cheaper approach. The win rate, now the win rate is when you no longer infringe. Right? So one case that I dealt with, there was a Walking Dead company Walking Dead are the people that sue you typically. I mean, you have competitor lawsuits, relatively rare, but Apple sues Samsung, sorry. That's a competitor lawsuit. Then you have the Walking Dead lawsuits, which is you have a company that's not going anywhere. They're making enough money that they have money to spend on something, but they're really not going anywhere. Zombies. So they'll sue their competitors to try to shake things up. So you might get a zombie competitor lawsuit. And then the last is the patent trolls, which are easy to deal with. So you get sued by a zombie, and this happened to one of my clients, and they just want to try to win. So we saw that zombie. The zombie had tech that was like, we don't care that much about it. We took that little thing that the zombie company was doing out of our product. So it was no longer at issue, right? We no longer infringe. Everything was past damages, right? So if you're not doing the infringement, you're still liable for 6 years back for the time that you were doing the infringement. That's called past damages, right? If you force them to change their claims in ex parte reexamination, because the claims changed, there's no past damages. It's only future damages. So in that competitor lawsuit, the win, which was approximately this rate, was do we change the claims enough that we no longer infringe or kill past damages? And the best result of all with those zombie lawsuits is with a 3 reexamination strategy, you kill past damages 90% of the time. At least 2/3 of the time, which is what I call the win, you get no longer infringed type claim amendments. And everything across the board is better with the cheaper approach. Right? So, funny. I could talk more about that, but like I said, I find it far more interesting than most other people do. So I think I'll just cut it off there rather than go through the slides. You can always talk to me about that if you want to, but let's do Q&A if you have any questions. I believe the microphone is for the...
Bill.
Okay.
So we're going to try and take as many questions as possible. I'll wait until 8:30. Bill is not billing. So let's use the microphone. Here you go. Go for it.
I don't bill anymore. I just do flat fees.
Well, I think towards the end I couldn't follow this killing and invalidating business. So when would a company choose to kill a patent, and what are the if someone infringes us, like they claim we are infringing their patent, is that when we decide, okay, so maybe let us try to kill their patent? Or if you want to patent something new and then we find something during the prior art search, somebody has already patented, so then do we go after them and then try to kill?
I'm glad you mentioned the prior art search because I have opinions about that. And my opinion is there is never a situation where you should do a prior art search. Ever. Just don't do it. There's no advantage to you knowing what the patent landscape is, exactly. Unless you're pharmaceutical. Right? If your offering is technology, it's tech, high tech, not pharma, I can give you a freedom to operate opinion. This is valuable because a freedom to operate opinion in a high tech space could easily cost you $250,000 to do it properly, right? And I'm going to do it for free. You infringe. There are so many patents out there, and there's so much that you do in high tech. You infringe. Sorry. Don't look for it. Don't open a can of worms if you don't need to. Just don't do a patent search. Now, I do patent searches to invalidate patents, but I don't do patent searches to file for them. Now, the reason why you do a freedom to operate type approach for pharmaceuticals is because you can find the molecule, right? If you find the molecule, you're done. You can't get a patent on that molecule. But if you do a search in tech, I guarantee you there's a patent out there that you infringe. Some aspect of what you're doing, you infringe. And then, there was a two-part question. And what was the other part?
And that was actually the first part. When and how do we choose which patent to kill? Is it when we want to actually file some new patent and then we search and then... Okay.
Yeah, so you'll know when you need to kill a patent because somebody sued you. Right? You don't go pick fights, for the same reason. You can, if you're in a competitive space, then there might be 100 different patents out there that just all, these are the competitors we have, right? Let's kill their patents? No, I mean, that's way too expensive. Even if you do it the cheap way, you're talking 100 grand for good odds to make the patent toothless, right? So you don't do that unless you're sued. I have defended against invalidation attempts when there was no lawsuit. I think it was dumb. There's one, I shouldn't mention any names, but there was a company that decided to invalidate a patent for a startup that was very cash constrained. I guess they knew they were cash constrained. And I just filed a continuation, right? So even if they knock the patent out, we have a continuation. We're going to have a patent at the end of the day. And then I also won, so the patent's fine. So we have 2 patents now. And they spent money and we didn't spend as much money as they did, and it was just a waste. I have seen other attempts to knock out a single patent. And that's a thing you might do, right? If you have a competitor and there's not too many of them because it's just not worth it to go pick fights. But if you have a competitor that's really getting traction and they have 1 patent and they don't have any patents pending, you can kill their patent, and maybe that's worth it. And I'd say, 95% of patents deserve to die. So you can probably knock it out if there's only 1. The problem is if they have multiple. And then I think she had a patent, not a patent. You had a question back there.
Yes,
you want to use the.
I have a few questions. The first one is you mentioned one way to leverage is to do cross-licensing. Can you just give a little bit more details about that?
So cross-licensing is a response to a negotiation typically. So like a lawsuit. So if somebody sues you, then my approach is always first, follow the next party re-exam. That's the first thing. Because if they're approaching you with patent, 40,000 grand is a drop in the bucket compared to what you're talking, almost without exception. So first try to kill it. You got a 1 in 10 chance of making it go away. Right? So that's approach number 1. And that can be going on in the background. Right? And then the next thing that you need to do is try to figure out a way to avoid litigation. Right? So 90%, I'm just making that number up. It's like 90%, I think, of cases settle. So, you should be in that 90%. There is absolutely, if you go to litigation, somebody made a big mistake. Right? There's almost no exception. And when you are trying to settle, there's really only 2 things you can offer up normally, licenses and money. Right? So if you don't want to pay as much money, you can say, all right, so you sued us, that's true, but we can countersue you with our patent. And we're not going to pay you as much money as you want because you owe us money too. But instead of exchanging money, let's exchange licenses, right? So there have been situations where, most of the time, I think it's like a face-saving measure. If somebody sues you, they're never going to agree to a cross-license alone. They always need token money, but sometimes the money is really small and they actually get a cross-license out of it. And they do that. I don't know if it's the litigators or the business people, but it's funny, if you ask a litigator how many cases have you won, every single one of them is going to say either 100% or 9 out of 10. And who loses, right? It's the famous, I guess the well-known expression, yeah, we settled, but we settled on terms that were very favorable to my client.
Yeah.
Of course you settled on terms. It's better than litigation, right?
Another question is, you said the most efficient way for a startup is to put as many inventions as possible to be covered as 1 patent. Right? For example, I have a couple of inventions I'm interested in patenting. One is the instrument. One is an instrument in pet grooming business. And then the other is AI, like in public health application. And the other one is in diagnostics in software. And these are completely not irrelated and not related. Is it possible to put them all under 1 patent or?
So I was being a little bit flippant with my approach, and sorry for that. The answer is yes, you can. Right, you can. Obviously it needs to be owned by a single entity, so it would be you or your company. The other thing is later on down the road, human beings are going to read these things, and if a human being reads it and they're like, "That's dumb. I just don't like that you did that," that can be a problem. Even though there's no legal reason why it needs to be a problem, that can be a problem. So, rubber ducky and self-driving car probably don't belong in the same patent, at least for that reason.
Yeah, and also if these 3 patents are under 3 different separate business, they should be filed separately. Right?
Oh yeah. No, don't. Yeah, you don't want to co-own patents. That's nasty. The other thing that that will come up, like, so I do recommend, if you're a startup company and you are cash constrained, which means you can afford one bucket, I do recommend you put them all together. You just have to keep in mind that means that they're stuck together, right? It's going to be difficult to separate them back out later, even through continuation practice, because if you file a patent on that rubber ducky and you file a patent on that, self-driving car, and you get a patent that issues on your self-driving car and you license it, well, they need a patent. They need to get coverage for the rubber ducky too, because I can file a continuation off the rubber ducky that goes back to the self-driving car. So they need a license going forward on anything that comes out of that patent application. So in that way, you can kind of burden your portfolio, or you burden your patent unnecessarily, because Google doesn't need a rubber ducky patent, right? So there is that. But in my experience, it's almost irrelevant. So close to irrelevant that I would say it is irrelevant, right? The value to you of having $10,000 more a year to build your business with is almost always going to be more important than separating out your patents.
The third question is, I have a patent that filed through a company that we are the founders, but we have unregistered a company. How should I what to do with the patent? I have no idea.
So patents are kind of like houses when you buy and sell them. So you have to register the IP somewhere. So you do want to make sure that you have your ownership tied up properly, right? I don't know if the number's still the same, but I remember 15 years ago, a friend of mine was talking about how he deals with mergers, right? And about a third of the time, there were ownership issues with patents, which is dumb because it's super easy to get it correct, right? But if you don't do it, it gets messed up. So you need to make sure that your inventorship's correct on the patent. This comes up a lot. It's like if you tell if I tell my client, inventorship, right? Don't ask anybody about it. Just tell me, who do you think's the inventor? And then I just take all the information and I make the decision. It's a question of law. It's not a reward. It's nothing like that. There have been cases where Japanese patents in particular are invalidated because in Japan, the culture is for, the manager or whatever you want to get, the bucho or whoever it is that's doing it, will put his name on the patent, even though he's not an inventor. In the United States, judges they're kind of like they're like software engineers in a way, in that they're very lazy. If they can make a problem go away easy, they'll make it go away easy, right? Inventorship is that easy way. It's like, oh, your inventorship's wrong, invalid, right? And you're done. They don't have to think about the tech. So you want to get your inventorship right, and then the next thing you have to worry about is assignment. So we actually have redundant assignments in patent law. I think everybody does. As a matter of law, employees give their IP up to the company that they work for. But we still make them sign an additional assignment just so we have like 2 places where it says, yeah, I'm giving you all of my rights. So you give your assignments up. If you're doing it properly, one company has the assignments from all of the inventors. And then as you go forward, you have to register it. It's like, title in your house. If you don't register the IP with the government and you start selling it, then a third-party bona fide purchase. I'm starting to speak Latin, but suffice to say that if you don't register it, you may find out you don't own it, right? So because it gets sold later down the road. So you just have to make sure that every time you pass ownership from one entity to another, you record it with the patent office, right? If you don't lose your IP, if nothing horrible happens, you can go back in time and fix it. But it's better to just keep it up to date. And it's easy, right? You just say to your patent attorney, check chain of title, please make sure this is correct, and they'll be able to check it.
I see.
I think
Sorry, I have a third question, last question.
Mm-hmm.
The last question is, so I have algorithm to file patent, and I heard that when I talk to patent attorney law firms, they always think it's very challenging to patent algorithm. And do you have any suggestions on the strategy for these?
Yeah, ignore those attorneys. That's dumb.
Okay.
It's, in some ways, it's a way to cover. I will tell my client when I think something's hard, but I will tell you that I shouldn't put this, You're going to edit this out later, hopefully. But there has never been a situation where I got a client that said, Bill, I need this patent. You have to get this patent issued. And I couldn't.
Oh, no. I think the reason they're saying is it's very easy to circumvent the patent.
Oh, workarounds. Oh, yeah.
Workaround.
That's a different issue.
Yeah.
So workarounds happen. That's
It's just like whether it's worth to patent it or we keep it as a trade secret, but we're going to publish this in a publication, a scientific publication.
Yeah, that's a legitimate issue. And that goes to your question about what do you do in your tech audit, right? Is the budget worth it for your patent?
Yeah.
I'm like my dad who's a surgeon. When I see a problem, I'm always like, patent. I can't help myself. I think patents are the right thing, usually. You can get a patent on it. What your patent looks like at the end of the day is open, right? So when I say I can get you a patent, that doesn't mean I can get you a good patent. I can get you a really bad patent, but I'll get you something. So you can say you have a patent, it's too narrow, there's workarounds, and usually what you do with the workarounds, and the reason why what you got was probably still bad advice, it depends on your budget, right? If you think of this is a big wall, but I'll go ahead and do it. Let's say that this white wall right here, that's your invention, the whole thing. And you have this idea that you're going to, you write all this different stuff in here, it covers your invention, but you can't get it. Because if you phrase it, a patent or a claim that says a system comprising a white wall. The examiner's going to say, well, white walls are very well known. You can't have a white wall. So what you get is like a paintball pellet. And you shoot it at the wall and you say, that's your patent right there. It's a huge white wall. But what's your patent budget? Because if you have a patent budget, then through serial filings, you can say, okay, I'll get a patent here. Now you have two, right? And at some point, this whole white wall, if you have sufficient budget to build it, will become a minefield, right? And when somebody wants to deal with you, you say, well, I got coverage, right? I don't have complete coverage. You can't get complete coverage. There's workarounds. But there's like 100 different things that we can get you for. I think the way this actually played out I wasn't actually there, but the story, one of the stories that's known, I think it was Intel visited I'll just say some company. It might not have been Intel. Sorry, Intel. Went into a startup company, and there was the startup was large enough that they actually had an in-house counsel, and they put a stack of like 10 patents. I don't know the exact number, but this is just a story. They put a stack of 10 patents on the table, and they said, all right, you guys need a license for these patents. You infringe. And the GC was like, okay, well, let me have a look at it. So he took the 10 patents, and he did a patent search, and he came back, 2 weeks later after spending all that time, maybe a month. It takes a long time to research these patents. And he said, well, these 4 here, these are invalid because we found prior art that was right on.
So do you suggest, sorry to interrupt you, just like, because they're waiting for the microphone. Do you suggest to patent for the application of the algorithm? Maybe that's a better protection, like in your view?
No, well, you're asking the wrong question. Don't worry about the form, right? That's not your job. That's the patent attorney's job. There's the law is that you cannot get a patent on software per se, an algorithm per se, but it's almost meaningless because you can get a patent on software that's implemented on a computer, right? So can you get a patent on an algorithm? The answer is no, but that's very misleading because I can get a patent on your algorithm. I just have to frame it appropriately. I think one of the first, or at least the first one that I was familiar with back in the beginning of my career, Taiwan was one of the first countries that codified the rule, you can't patent software. And it was immediately the easiest place in the world to get software patents because now we knew what the rule was. You just can't say that certain thing, you say this thing, right? And now everywhere in the world you can get software patents, and everywhere in the world there's like rules about how you have to phrase it, right? So that's not your job. Your job is to identify value for your patent attorney. Your patent attorney's job is to get you the best patent that covers that valuable thing that they can, right? Don't worry about form, right?
Next question.
Hi, you mentioned before that one of the 3 options to protect was a defensive publication. With that, I mean, you protect yourself that no one else is going to file a patent and stop you from using that IP, right?
In theory.
Okay.
So defensive publications don't really work very well. So I don't want to make it sound like that's a great thing. You should only do them if you have to, right? You don't say, we have trade secrets, we have patents, and then let's do this because we think it'll stop somebody from getting a patent. No. You say, we need to disclose this because people have to understand what we're doing. So we'll disclose it, and we'll disclose it in the way that gives us the most benefit for having disclosed it. But you don't say, let's disclose this so nobody can get a patent on it, right?
So, for instance,
Doesn't
if
work.
you're talking to investors and you're telling them what you're going to do,
Well, yeah. I mean, if you're talking to investors, of course, they're going to say we don't sign NDAs, right? And then what you say is, yeah, but this is confidential, right? And they'll say yes. And that's actually kind of an important thing. So if there's one takeaway you can all have from this, if you go into an investor who will not sign an NDA, which is typical, then you don't just say, well, okay, well, we'll just disclose this to you, and you can tell whoever you want, right? You don't say that. You say, okay, but this is really important to our company. Don't disclose this to anyone, okay? And if they say yes, which they always do, then you have what's called an oral NDA, or verbal NDA. You can never enforce that in court because it's going to be like you go and the judge says, did you have an NDA? And they'd be like, no. Do you have an NDA? Yeah, we did. I don't know.
But you would take it court with the consent, no?
Yeah, good luck. Yeah, piss off the investors. No, but what you'll get is a subjective belief that they will not share. And from patent perspective, that's all you need because you're not going to sue the investors. You just want to be able to say, yeah, we didn't disclose publicly. And as long as you can say that and you're not just making it up, then I refer to this as going to the evidence. Somebody's going to have to, if they want to show that you disclosed publicly, they're going to have to find proof, right? And good luck going to one of these like well-known investors in tech and saying, so they told you their secrets. Did you go blab about it on the internet? Well, of course they're not going to say yes. So that's enough for you. So don't. I think that most of the time, if you're letting an NDA get in the way of your business strategy, you're probably making a mistake. So do the best you can to get a verbal NDA. I think he has one back here.
Did I hear you earlier say that yes, you can patent software, that there are strategies to patent software?
Yeah, you have to make sure that you do it right. So the software is very much patentable. It always will be. There's no way that it can be changed. I mean, the Supreme Court has tried to make it so you couldn't get software patents, but it just doesn't work. And the reason for that is when you try to describe, what is it that you really get when you get a patent? Well, it's an algorithm. It's an instruction even for something like a patent on this computer. When it's on paper, you're describing something that's basically this computer, but it's abstract. By its very nature, it's abstract. And software described like in a computer is no less abstract than this ringer described in a patent. They're both abstractions, right? And so when there is an effort to invalidate patents through this software approach, it invariably fails. It's basically saying you can't have a patent on a thing if it's implemented on a configurable device, right? Which just doesn't work. So you just need to make sure that your patent attorney describes it properly, right? And it's not difficult. It just has to be done properly. I once had I know I like stories too much, but I once had a patent that was the problem with the patent, which I inherited, but it didn't ever mention a computer. Right, so I had this software patent and nothing about a computer. So the examiner said, well, you can't have a patent, no computer. So I had to file what's called a continuation in part. I added a computer. I said it's not new matter, really, because computers are known. And then I just said all this stuff, yeah, it's on the computer. And then I got a claim to that. Right, so even after the fact, I was able to fix it. Do it right the first time, but if you do it properly, you can get a patent.
Next question.
That's a short one. I know you said that the bar dates are not important and we shouldn't.
Not as important as the other considerations. Budget first, business value second.
To make sure I know correctly, because I heard that even if you disclosed in confidence, like in that investor meeting, and your investors confirm that they will not tell anybody, so verbal NDA, does that set your bar date, like starting of the 1 year?
That's a good question. The answer is, as is frequently the case in law, is gray. There's things that happen sometimes. I don't think you should stress over it, but if you disclose, for example, to too many people in the industry, right? So every one of them signs an NDA, but you disclose to every important person in that industry, that can be treated as a public disclosure because now all the relevant people know, even though you have signed NDAs, right? So it's not always fair, but the thing that you need is money to get patent protection. And as long as you're disclosing things but you don't have any real money or you're not near money, it doesn't matter that much if you miss the bar date because you're still going to keep trying and you're going to try to add new things to it. But every disclosure you make is risk, right? If you tell your wife, it's risk, right? Maybe she's going to tell somebody, who knows, right? So treat every disclosure as a need-to-know basis. I mean, it's trade secret, it's need to know. If you need this person for your business to do better or there's a good chance it's going to do better, don't worry about the bar date. I mean, ask your attorney, right? Do we have any dates we have to beat? Well, sure, there's always dates you can beat, but still stay focused on budget. Right? There's not much you can do sometimes. And I mean, you can always file a provisional application. Like here, if you're really paranoid, which is not a bad thing, paranoid's fine. But if you're really paranoid, you give a disclosure to an investor and you have a slide deck. And after you give that disclosure, you send your slide deck to your patent attorney and you say, I don't want to add anything to this because I don't have any budget, but I believe the filing fee is $130. So can you file this slide deck with the patent office? Yeah. And then if you convert it within a year, you can claim priority back to it. Now, those types of provisional filings are virtually worthless. I typically, when I'm invalidating a patent, I will try to undercut that provisional very quickly if it's not identical to the non-provisional that's later filed. And it's typically not that hard to do, but it's good for storytelling. Like if you're disclosing and you do ultimately get a patent, but there's a problem with your date, I mean, the person that you're suing, if they're the one you disclose to, they're not going to want to get in front of a jury and say, yeah, we did this right after the disclosure, but that doesn't count because the technicality. So they might want to make that go away. So it's still decent for storytelling purposes. And the other thing that occasionally will happen, just as a follow-up, because you can do it relatively inexpensively, if you do file best practice is file a patent before you disclose to anybody, right? NDA or not. But you file your patent, you go into a disclosure, and they ask you questions. And you think, well, the answer to this question is not in my patent, right? So, and I call this going off script. Your patent's your script. If you describe something that's not in there, then you can quickly follow up with the attorney. Now, you already wrote the patent, right? So you just need to add a couple of paragraphs. So you say, I told them about this thing. Here's a diagram. Here's a description of the diagram. File a provisional. And you take the old patent application just as it is. You add some text to the bottom of it. You put one more figure in it. You refile. And if you get that in on the same date, it's relatively inexpensive. And you can let the other one typically go for a while. And I won't go into the dates and timelines, but you have to be careful with these things, but there's usually a way.
Question about you mentioned something about your continuation in part on your previous questions. Yeah, so we actually have a patent pending, but we discovered that there was some artwork prior that was actually abandoned. So we actually came up with some new, we're filing for a CIP, and the attorney feels like there's grounds for it. But I was just questioning like the success rate you had with the CIP in the past.
Okay, so continuation in parts are usually filed, in my opinion, because there was a mistake, right? So you don't file a CIP if there wasn't a mistake, right? In the scenario that I was describing, there was a big glaring problem in that computers weren't described in a software patent application. You have to have computers because if there's no computer, there's no physical medium to put your software into. Right, that's a problem on the law, right, the basis of the law. Now, most people file CIPs incorrectly, right? In my opinion, CIP filings are almost always wrong. Say 9 out of 10 times you shouldn't have filed a CIP, right? And that happens when the patent on itself, or the patent can stand by itself. You don't need to file anything on top of it in order to get claims to that original patent. When that's the scenario, you shouldn't file a CIP. But sometimes you'll do it because you need one patent pending at a time, like if your budget's too low. But if you, assuming you have the budget to have two parallel pending at the same time, you don't put them together in a CIP because you get the worst of both worlds, right? The CIP will give you the oldest priority date. Well, there's some exceptions, but just for the sake of argument, you'll get the oldest priority date for the sake of patent lifespan, but you'll get the most recent priority date for the sake of prior art, the worst of both worlds. So you're better off, and you can avoid that if you don't claim the new matter, but then why do you have the CIP in the first place, right? So you're better off, typically, if you file the patent application and you keep it by itself, and then later, if you feel like you should change it, unless there's a critical flaw with your filing, you just file a new application. You don't file a CIP.
So you're suggesting to file...
I don't know the facts, so I'm just suggesting that probably that's wrong.
So you prefer filing a whole new patent than doing a CIP on an existing patent with the prior art with that oldest date?
That's right. CIP doesn't help you with prior art. And if that's what they said, then yeah, you probably want a different attorney.
Probably. Thank you.
All right.
He needs that for
So,
recording.
maybe one last question. Here you go.
So what's the timeline for patenting a business process?
So, yeah, business process is something you shouldn't worry about again, right? Attorney's job is to get a patent. Your job is to describe where the value is. If you're unfortunate enough to get stuck into the art unit at the patent office that deals with business patents, then your allowance rate goes from something on the order of 60% industry-wide to about 5%, right? So the process, the approach that you should attempt to take is to avoid describing it as a business process. Right? You describe it as tech. And if I can do that, normally what will happen is my client says, I have this business process. And it's like, don't tell me about the business. I don't care about your business process. Tell me about the value. And then I attempt to find tech in those different spaces. And I don't want to talk, last thing you would ever want to do is say, in your claim, a business process comprising. Because then they get at the patent office and, oh, let's send it to the place where they never allow patents. Right? So you focus on something different. Describe your business. The business process will probably be in there, and your claims are hopefully going to be directed to something more related to tech than the business process itself.
How useful would it be to have a patent here if the operations are in Asia, like India and Singapore?
That's a very good question. So how useful is it? Hard to say. There are cases, infringement is national in scope, and divided infringement across boundaries can get really complicated, right? So you want your patent infringed in its entirety in the country in which you're protected, right? So do you get a patent? Well, India, I talked about it being weak on patent. It actually is getting better in India for software. There's been some recent cases where it looks like patent is starting to get a little bit more quality control in the courts, a little bit. So you might want to get something in India. But your problem, probably, if you're here, which means you're a startup entrepreneur, not 10th employee at Google, your problem is budget, right? So where are you going to protect yourself? Well, you got limited number of choices. You're probably not going to go everywhere, and India is pretty far down the list of places where you might protect yourself. Usually it goes, not surprisingly, it goes to some extent based on the size of the market. If you know your business well, you might be able to say, yeah, but Madagascar is pretty good for that. Well, it won't be Madagascar. But, some country that normally doesn't rise up to the top, like a China or Europe or Japan, you might know that it matters more there. Brazil maybe. But for the most part, you're going to have to cut your patent filings off to avoid the crunch that's going to result in you abandoning them. India usually doesn't make the cut. And this is true of all companies, not just small companies. Big companies make the decisions too. So yeah, India rarely makes the cut.
If the operation doesn't exist here at all, it's just relevant to the Asian market.
Yeah, you because patents are not a license to do it, their license to stop people from doing it. We typically will file, not typically, but, if we have a foreign filing practice, we will go China, even if you're only doing it in the U.S. We do that with some frequency because you're worried about the global market, right? Most people are thinking, well, this is going to be, even though I'm practicing only in the United States, there's other companies that are doing this in lots of different places, right? If you can stop them from doing it in China, that's a really powerful leverage, right, to make them do what you want in the United States, right? So you can use the patents where there's value. It's not necessarily where you're going, although it just feels weird for some reason not to file patents where you're going, so most companies will do it. But as long as there's not a working requirement, technical term. A working requirement is some countries require that you actually practice your invention in that country. So ignoring that for the moment, if there's no working requirement, a patent in a big market is better than a patent in the small market where you are.
All right, let's give it up for Bill.